Today's podcast is about judicial independence and transparency through RTI. The case number CA 10044 by 2010 was between the Central Public Information Officer, Supreme Court of India as petitioner, and Subhash Chandra Agrawal, High Court of Tripura, High Court of Calcutta was the respondent. The lawyers for the petitioner were B. Krishna Prasad and for respondent Prashant Bhushan, Sunil Fernandez. The case was decided by 5 judges bench, out of which 3 were Chief Justices of India, namely Chief Justice N.V. Ramana, Chief Justice D.Y. Chandrachud, Chief Justice Ranjan Gogoi, and Justice Sanjeev Khanna and Justice Deepak Gupta, other 2 judges. In this case, the Supreme Court held that the need for judicial independence does not contradict that of transparency. 3 key issues in the case are: Number 1. Does public disclosure of information held by the office of the CJI and collegium curtail the independence of the judiciary? Number 2. Does Section 8, I.E. and or J of the RTI Act exempt the CJI from public disclosure of information on the grounds of protecting fiduciary and personal information? Number 3. Would disclosing the information pertaining to collegium decision-making prevent collegium members from deliberating freely and frankly? Now let's get to the case details. In November 2009, the Central Information Commission ordered the Supreme Court of India to disclose information regarding the collegium's decision-making. The Central Information Commission order pertains to a right to information request made by activist Subhash Chandra Agrawal. In particular, the Central Information Commission ordered the Central Public Information Office of the Supreme Court to disclose correspondences between the collegium and the government regarding the appointment of Justices H. L. Dattu, A. K. Ganguly, and R. M. Lodha. At the time of appointment, these 3 judges were less senior than Justices A. P. Shah, A. K. Patnaik, and V. K. Gupta. Note that the Central Information Commission is a legislative body constituted by the Right to Information Act, 2005, designed to autonomously ensure the execution of the RTI Act. The Central Information Commission comprises a Chief Information Commissioner and up to 10 Information Commissioners. Section 12(3) stipulates that the Central Information Commission members are appointed by the President of India on the recommendation of 1. The Prime Minister, who is also the chairperson of the Central Information Commission. 2. The Leader of the Opposition in the Lok Sabha. 3. A Union Cabinet Minister appointed by the Prime Minister. The Supreme Court appealed the November 2009 Central Information Commission order to itself. On 4th December 2009, the Supreme Court stayed the Central Information Commission order. The stay order is still in effect. The legitimacy of a similar Central Information Commission order had come before the Delhi High Court. On 6th January 2009, the Central Information Commission ordered the Supreme Court to disclose information regarding judges' personal assets, putting into effect Subhash Chandra Agrawal's RTI request. Agrawal sought to find out if Supreme Court justices had declared their assets to the Chief Justice of India. The Supreme Court's cpio challenged this Central Information Commission order in the Delhi High Court. On 2nd September 2009, a single-judge bench comprising Justice Ravindra Bhatt upheld the Central Information Commission order. The Supreme Court cpio appealed, and in January 2010 a 3-judge Delhi High Court bench referred it to the Supreme Court. On 26 November 2010, a 2-judge Supreme Court bench led by now-retired Justice B. Sudarshan Reddy referred the matter to a 3-judge bench. Justice B.S. Reddy framed the central issues at the heart of the case. 1. Would disclosing the information requested by Subhash Chandra Agrawal interfere with the independence of the judiciary? Is it therefore not in the public interest to disclose this information? 2. Would disclosing the information requested erode, I. The credibility of the collegium's decision and or 2. Curtail the future free and frank expression of collegium members when appointing judges to the Supreme Court. 3. Does Section 8, I.J. of the RTI Act exempt the cpio from providing the requested information? Section 8, I.J. exempts the disclosure of personal information that has no relationship to any public activity or interest. On 17 August 2018, a three-judge bench comprising now CJI Ranjan Gogoi, retired Justice Prafulla C. Pant, and Justice A.M. Khanvilkar referred the matter to a five-judge constitution bench. They held that the matter involved constitutional questions relating to the separation of powers, independence of the judiciary, and the right to privacy. On 4 April 2019, the Constitution Bench reserved judgment. On 13 November, the Supreme Court pronounced its judgment. It held that judicial independence does not stand in contradiction with the need for transparency. It observed that whether or not the information is subject to public disclosure must be decided on a case-by-case basis by weighing competing public interest claims. For example, the right to information may have to be weighed against the right to privacy. On the first Central Information Commission order pertaining to collegium decision-making, it directed its cpio to re-examine the request, but by taking into account the objections, if any, by third parties, as stipulated under Section 11(1) of the RTI Act. On the second Central Information Commission order pertaining to personal assets, the court upheld the Delhi High Court judgment and directed the cpio to disclose the relevant information to Subhash Chandra Agrawal, the respondent. Thank you for listening to the Verdict India podcast.